sports, news, and talk. A reminder, the answers given on this show do not constitute as legal advice and do not create an attorney-client relationship. For legal advice, you can call the office at 1-800-DeWitt Law. That is 1-800-339-4885. Moses DeWitt is an attorney with the DeWitt Law Firm and has been practicing law in Central Florida for over 10 years. And again, if you want to call the office and set up an appointment, you can do that at 1-800-DEWITT-LAW. That is 1-800-339-4885. Also, don't forget, shoot us some emails if you have any legal questions, curiosities throughout the show to ask@DeWittLaw.com. And we'll play those or read them out live on the air and answer them and kind of have a discussion based off of them. And again, you don't have to have a legal question pertaining to you. It can be somebody you know, or it can just be something you've always wondered. You can send those in, ask@DeWittLaw.com. We'll get to those a little later on in the show. Mo, how you doing? Good morning.
Good morning to you. How are you this morning?
I'm doing good. I'm doing good. We're full on into 2022. Last week, we recapped some of the new laws going on. We are featuring another one of our final train shows today, which is very exciting.
We might have a couple more train shows before that ordinance gets passed, where we no longer hear the train in downtown Orlando.
We should have a couple more, but it went by right before we started today, so I'm worried we're not going to get it. But hopefully, fingers crossed, we'll get another train horn.
I think we might be in luck. We might just pull it off and get you another train horn in the background there. But yeah, off to 2022. We're only a couple weeks in now, but it seems like it's just chugging along here.
Well, what will happen is we'll blink and it'll be March.
Exactly.
It's just how it seems like everything is working.
I feel like we should just turn the show into talking about how time passes too quickly. That's most of what we do around here.
It seems to be a premise that we focus on a lot, but it's just important that we make light of the fact that time is going really fast. I don't think we talk about it enough.
No, we don't.
Mo, you've got some good stories, topics for us to kick off with today. We did the changes to 2022 last week. Let's go ahead and dive into some things that we found early on.
Yeah, I thought we'd just talk about some fun legal stories, or I guess depending on your opinion.
Depending on your it depends on which side of the legal perspective you were on in the
exactly.
case.
But just some legal stories from around the country. You know what's a very dangerous place to work, Chris?
Oh wow, coal mines,
law firms.
Oh,
so there's a case, and this is out of Denver, where the airport's general counsel had to resign. You want to take a guess why he had to resign?
I don't, but I'm excited to find out why.
He slapped his subordinate.
Oh,
usually frowned upon. What's kind of even better about this article is he slapped his subordinate when he was doing a demonstration on police de-escalation practices. This is his defense to the whole thing.
Okay, all right.
So I'll walk you through it. So At first, the lawyer completely denied slapping the person at all. So it didn't happen, yada, yada. Okay. They did an investigation. Turns out he did. So then the story kind of evolved to, they were talking about police de-escalation techniques for the airport, I would assume, because this is the airport's general counsel.
Right.
And he slapped his subordinate somehow as some sort of demonstration for police de-escalation techniques. And I don't want this to go into a conversation about, police de-escalation or anything like that. But it seems like an odd defense there.
It does. That doesn't seem how a police officer would ever de-escalate a situation.
So he said it was
you
because
just imagine
of that.
at a traffic stop, a policeman or policewoman just open face slapping the person that they pulled over? I don't think that would help the situation.
In some cases, they might be so shocked that it may actually work. I don't know. But here's what he says about it. He goes, while my intentions were good and I am very passionate about this topic, unfortunately, it appears that at least one participant found the exercise embarrassing and inappropriate.
It almost feels like you put on an exercise for an excuse to slap your employees.
I mean, maybe that's one way to try to...
Mo, stop taking notes. Stop. No, that's not. You're not supposed to be doing that.
Still frowned upon?
No. Oh man, that's a wild one there.
Yeah, so it didn't end well for that guy. He has to resign. Somebody else has taken over for him. But usually just not a good practice all around.
No, abuse, actual physical violence in the workplace is never good.
No, I just found his explanation for it almost more bizarre than the actual act.
It's almost kind of impressive.
To some degree.
It's a stretch, to stretch that far and really hope that police de-escalation by slapping somebody is
Well, and also, why is the lawyer demonstrating police
really
de-escalation?
that's the question that we should have been asking right from the get-go here. What are we doing in that situation?
Yeah.
Why is the lawyer doing that?
Probably not their area of expertise by any means.
Again, it sounds like they just wanted an excuse to put their employees in a line and just slap each one of them one by one.
Yep.
Interesting. What's next on the docket?
Have you followed the Elizabeth Holmes case at all?
So a little bit. I have a little bit, but not entirely.
So I mean, obviously, there was some. She was found guilty of some of the charges that were brought against him,
Right.
or against her. Sorry. And for our audience who maybe hasn't been following it, she was the CEO of a company called Theranos. Is that how you pronounce it? Theranos.
Theranos. Yeah, it would Theranos in quotation marks essentially.
Yeah. And it was supposed to be this company that had this, super advanced medical blood testing system that claimed it could do all this stuff. And it was one of these, Silicon Valley type companies that raised a bunch of money. I think Rupert Murdoch was a big investor in it. Maybe Bill Gates was involved in it or an investor. I'm not sure on that one. It had some big names behind it either way. And it turned out it was just all kind of a hoax, and they were really just taking the blood tests and sending them to traditional labs who were doing the blood testing.
Yeah, it was almost like an Enron type of situation again.
Yeah, and she, her excuse was, or her defense, I should call it, was that she didn't know anything about it, and that the person who ran her lab was sending it out to these other labs, and she didn't know that, and she thought the technology was good, and so on and so forth. But I mean, she was kind of a rock star. I think she graduated from Stanford at
she's
19 or something.
She graduated super young, and she was just kind of enveloped in this, wow, she's gonna change the world type of persona and everything like that, and almost was I had a celebrity status of sorts, I would say.
I think in kind of the Silicon Valley investment world there, I think she was kind of a celebrity. And at one point, I think they estimated her net worth to be like $4.5 billion.
And they just made a Hulu documentary or show, something. I think it's a show. I don't think it's a documentary.
Okay.
About it. Amanda Seyfried, I don't think I'm saying her name right, plays Elizabeth Holmes.
Yeah, Seyfried.
And they I saw a photo of her online. It's with the black turtleneck and everything, and it looks just like her.
There you go.
So I mean, if you are that popular enough where your story is going to be created into a television show, they definitely put it on celebrity status. But so she was guilty on a few of the charges.
Yeah, for the 11 federal charges, she's now facing up to 20 years in prison. I doubt she'll actually get that much.
No, of course not.
But and I'm sure there's going to be some appeals that come from this as well. But kind of an interesting, fall from grace for someone who is obviously very bright, was surrounded by a lot of bright people and a lot of wealthy people, and ultimately seems like kind of defrauded them with this fake technology that didn't really exist. We've seen a couple of these cases. There was the guy with the electric vehicles who I think recently kind of was indicted on something similar. Not Elon Musk, obviously.
No.
There was another guy who was creating a similar company that had these electric vehicles that were supposed to. One of them was a semi truck, and we're supposed to kind of. It had the name's escaping me. It'll come to me later, but basically, he claimed that he had these great batteries that could run longer than Teslas, further than Teslas, were self-driving, completely automated. And they did these demonstrations, these video demonstrations, and it turns out the whole thing was a fraud. It's completely made up. That the vehicles didn't actually do what they said they did. They didn't have the prototypes, and they just kept raising money and essentially stealing money, with no real hopes of actually producing a vehicle or producing a vehicle for the masses.
Trevor Milton, Nikola.
Yeah, Nikola
Corporation.
Yeah.
Okay.
I knew it was similar to Tesla.
Yeah.
It was something like that. And so I think he's faced, I don't think he's gone to trial yet, but he's faced a few indictments at this point, but was still raising money fairly recently. I know he got some flack for that as well.
Yeah, it looks like, he was still, he didn't even resign until 2020.
Yeah.
But federal investigations had started by that point as well. So, it looks like he just kind of kept going about doing shady business while under investigation, and then is now going to face some consequences because of it.
Yeah, I mean, it's interesting to see these kind of, and I guess we've always had it in one realm or another. It's just now, with kind of the way funds are raised for these companies, you see it maybe go on more, where these people put on this front, surround themselves with kind of the right circles, the right people, and people just dump a ton of money into it, when really there's no product on the back end. And maybe in some cases it starts out with good intentions and they're hoping they'll be able to create a product, or they have an idea for a product. But in some cases, it just turns out to be a fraud.
Well, I might be naive on this, but I have a feeling that we're going to see more of these instances with the way that Bitcoin transactions are happening all over the place. And I think specifically in areas like Miami, where you're seeing a massive, massive influx of people from Silicon Valley now moving to Miami, and a lot of Bitcoin people popping up in Miami. It just doesn't mix well.
Whenever everybody is talking about a topic like that, and there's a lot of money moving around, there's always a lot of opportunity for fraud.
Right.
Yeah, because everybody wants the get rich quick scheme, and as we've learned, people will play into that, and people will take advantage of people who want that.
Yes.
And so I think you're absolutely right when, in places like Miami, or where there's a lot of movers and shakers, and they're saying they can do this and they can do that. I'm sure we're bound to see some Ponzi schemes or whatever new scheme they come up with down the road, which will ultimately lead to some indictments and some charges, most likely.
We got about a couple minutes left here. Do you have another one we can get to here?
Yeah, I'll just do this one real quickly. I just thought it was good to let the listeners out there know. Recent jury award for a tank mechanic with the United States Army of over $13 million for damages against the 3M earplugs. A lot of people in the military use these 3M earplugs. They were defective. They ended up with ultimately permanent hearing loss. And so this is one of the first and one of the largest jury awards, over $13 million. If you or a loved one was in the military, has any hearing loss from using these earplugs, definitely reach out to an attorney, because they are moving forward with these cases.
So that was my follow-up question there, because I guarantee you that there's probably listeners out there who may not have even realized this just happened, and have probably dealt with maybe some hearing loss because of this as well. And so best way to get involved with this $13 million lawsuit that you probably could be entitled to some of, right?
Well, so they would bring another lawsuit for you. But if you or a loved one has this issue, reach out to us. We'll get you in touch with the right people who are handling these cases. They're very specialized cases, but that is why I like to bring them up, because these are the type of cases nobody even really knows exist. Nobody really thinks about. They probably were in the military and then just were like, oh, I have hearing loss. Never put the two together. But a lot of people who are in the military who use these 3M earplugs apparently do have permanent hearing loss. And so now that's why these lawsuits are being brought against 3M.
There you go. And again, if you know someone who's experienced that, go ahead, give Moe a call. Give the DeWitt Law Firm a call here. 1-800-DeWitt-LAW. 1-800-339-4885. 1-800-339-4885. Also, you can check them out online, DeWittLaw.com. Don't forget, that's DeWitt with 2 T's. Plenty more show on the way. You're listening to the DeWitt Law Review on WDBO 107.3 FM and AM 580.
I was visiting the local resort when I had an unexpected slip and fall. I reached out to the DeWitt Law Firm and was put in contact with Philip Wayne. Initially, the insurance company offered me a low-ball amount, and I was able to secure over 10 times that amount from Philip Wayne and the DeWitt Law Firm. I'd like to thank them for all their hard work and recommend them to anyone who's looking to have an attorney. If you're injured on the go, just call Moe.
Welcome back to the DeWitt Law Review, WDBO 107.3 FM and AM 580, Orlando's news and talk. Chris Crawford and Moe DeWitt with you here. And of course, if you want to check out the DeWitt Law Firm, give them a call, set up an appointment. You can do that at 1-800-DeWitt-LAW or 1-800-339-4885. Also, don't forget, if you've got a question that you kind of have throughout the show, or just a general legal question that you've had for a little while, you can email them to us, and we'll read them out on air and answer them and have a little conversation based off of them. Just send them into ask@DeWittLaw.com. Ask@DeWittLaw.com. Moe, let's go ahead. We got one more or a couple more stories we can get to before we get to the break. What do we got?
Yeah, I'll do just this one real quickly. I don't know if you followed this at all, but the Nirvana baby lawsuit.
Yes.
So the kid who was an infant at the time, who's on the cover of the Nirvana album, what's the name of that? Nevermind, which was a pretty famous album.
It's one of the more famous album covers, even, I would say.
Yeah, I think you're
probably maybe
accurate
more
on that.
known for the cover, if anything.
So if you're not familiar with the lawsuit, basically the infant who's on the cover is now suing Nirvana. He's now an adult. And he's filed a lawsuit basically claiming that the album cover is child pornography and things of that nature.
Heady play.
What?
I said it's a heady play.
Yeah, it is. And Nirvana's defense to it is basically that he's profited on this entire life. He has a tattoo of it on him.
Yeah.
He's made talk show appearances. He's signed album covers, all this kind of stuff. He's reenacted the photo apparently. But basically, the judge has dismissed the lawsuit, but has given the plaintiff here another opportunity to amend the complaint. So the real issue here, besides kind of the defense and the details, we're really not even into that stage of the lawsuit yet. Yeah, the real issue is the statute of limitations has lapsed.
Ah, okay.
So the judge dismissed the claim, but allowed the plaintiff to amend the complaint if they can show a way to get around the statute of limitations. So in certain circumstances, there are ways to get around statute of limitations. They're very limited circumstances, and they have to be typically pretty factually specific. So, for example, with a medical malpractice claim, for instance, it's usually a fairly short statute of limitations. Most cases are 2 years. However, if you can show that there was a reason you would not know of the claim until a certain period of time, then that may be a way that it extends the 2-year period. It would be 2 years from when you knew or should have known about the claim, essentially. So here, the judge did allow them to amend their complaint, which is the proper thing to do. It will be interesting to see if they actually try to amend the complaint, if they can come up with anything that circumvents the statute of limitations. But at this point, it's been 30 plus years, I think, since this album came out. He's been an adult for quite a period of time. So I think it's a very tough case for them to bring.
I mean, I smelled something right away, right? With like I saw this story and I thought immediately, like, okay, this guy had somebody who told him that there might be an opportunity to make money off of this from a legal perspective, right? Like this had to be that sort of situation. He was kind of like, oh, you know what? Yeah, let's do that because the more I read into it, the guy has made appearances. He's talked about it. Like I thought this was somebody who had been living in the shadows with this and just like people knew that it was him, but like, no, he has made this very clear. He is that baby.
I mean, to me, this does not seem like a very well thought out plan.
Not at all.
At all.
No.
Not a very well vetted lawsuit, not a very well thought out plan. And you kind of wonder what the attorneys in this case are really doing. Do they actually know what they're doing? Is there something that they know that we don't, or is it just not well thought out?
I think it might just not well thought out. I think the guy is just trying to make a little extra money somehow. But I saw that one and immediately was like, this is too convenient of timing for this guy to be really going after. What else we got there?
Last one, and I only read this article because it reminded me of one of my favorite shows, Better Call Saul.
Oh, okay.
Where a defense attorney was convicted in a $1 million federal money laundering case. His client was bringing him large duffel bags of cash, and he was running this money through his law firm and then making investments in retail and entertainment type investments for the client. And his claim was he thought the money was from the client's marketing company, had no idea it was related to illegal activities, even though he represented the client on some illegal activities. But just seemed a very Better Call Saul.
It is. That's
altogether.
right. That's right out of the show.
Yeah. Usually, anytime someone shows up at your office with a duffel bag of cash, that is suspicious.
You had to wash the money.
Got to wash the money. So, yeah, he's in a whole load of trouble, to say the least. Not looking real good for him.
Well, it also goes to show that as good of a television show as Better Call Saul is, it's not that easy to take duffel bags of money and then turn around and hide it in car washes and media and entertainment.
Well, I guess we could interview this guy and find out.
Yeah, and I just do think that's the great way. Yeah, I just thought it was from his marketing company. Like, I don't ask me any questions about his past or the things that I've represented him on in previous cases. We'll just focus on this. All right, Mo, appreciate that one. We've got your emails coming up. If you want to send an email in for next week's show, you can ask@DeWittLaw.com. Ask@DeWittLaw.com. Don't forget, if you need to call to make an appointment, 1-800-339-4885 or 1-800-DeWitt-Law. Plenty more show on the way. You're listening to the DeWitt Law Review on WDBO 107.3 FM and AM 580.
Here's a little attorney secret for you. Hiring any attorney is always better than hiring no attorney. I know every day you get inundated with attorney ads on the radio, on television. Everybody's saying, hire me because I do this, or hire me because I do that. At the end of the day, if you just hire an attorney for your injury case, in my opinion, you're always going to do better. Yeah, the insurance company does know the attorneys who go to court. They know the attorneys who are going to fight them. And they do know the attorneys that are going to accept the last best settlement offer. But at the end of the day, if you don't hire an attorney for your injury case, in my opinion, you're always going to lose.
You're listening to the DeWitt Law Review, WDBO 107.3 FM and AM 580 Orlando's News and Talk. We're going to get to your emails here in just a moment, but you can also remember, check out the show on YouTube and Facebook. We do put it up there so you can catch some of the past shows and this show if you missed something from the first half, or if you heard something you want to go back and listen to it again. You can do that there. Facebook, just search DeWitt Law, and also on YouTube as well. And then make sure you do that on all the other social medias as well, because they do a lot of fun stuff. Moe does a lot of fun stuff on all the social media. But let's go ahead and check out some of these emails, and you can always send in your emails. You've got a question to ask at DeWittLaw.com. That is ask at DeWittLaw.com. Mo, our first one. I'm renting a home, and the AC is not blowing properly to the master bedroom, so it is very hot in the master bedroom, even with a cold winter. We advised the property manager, and they already sent an air conditioning tech, and he said all the vents need to be changed. The landlord sent an insulation guy to do insulation. That person said the vents were fine. So landlord is going back with a rental property and said he doesn't want to change anything, even though insulation guy is not an AC technician. The rental property decided to get an AC unit for the master bedroom, but we do not want it in there since I believe it will raise our power bill. Is there anything we can do legal-wise about this to have the landlord either fix it or cancel our agreement and return our deposit and just move somewhere else? We have been in the property for 1 month out of the 12 months, and we told him about the AC from day one.
Well, from a legal perspective, I don't think there's much that you can do. There's no requirement here or statute that the landlord's breaking that I know of off the top of my head. So then you're going to want to look at your lease and see what your lease says. Are there any specific provisions in the lease that may be violated? Again, I'm guessing there's not, and it sounds like the landlord's trying to make this right by adding that extra unit in the master bedroom. Now, one solution may be if you don't want the power bill to go up, you just don't run the unit, frankly.
Yeah.
But otherwise, I would have a conversation with the landlord and basically see if you can get them to let you out of the lease. Maybe you can reach an agreement where, hey, you'll stay there until he'll put the property back up for lease. You'll stay there till he finds somebody else to take your spot, and then, work out some sort of arrangement like that. From a legal perspective, though, can't talk. From a legal perspective, though, I don't think there's really anything here. I think this is really a situation where you guys kind of need to work it out. Ultimately, though, the landlord most likely has a valid lease with you, and he or she has not done anything wrong to violate that lease. So unless they let you out of that lease, you're going to be stuck in the property. And frankly, it sounds like they're trying to make accommodations. They're trying to make things right. So I would just continue to work with them, be reasonable with them, and see if you guys can work it out.
Yeah, and I understand that it might raise the power bill, but maybe then you just turn the AC in the rest of the house down at the night or something like that. But because as far as it's concerned in Florida law, you just have to provide AC.
I think technically the statute says you have to provide heat. I don't think there's actually a requirement for AC, which is kind of funny.
I did not realize that. I thought it was.
I think it's actually the other way around.
I thought because of Florida and the temperatures that it had to be AC.
One would think. It's been a little while since I've looked at that provision, but I believe it's actually the heat that has to be provided.
Interesting. So, wow. Yeah. So this case scenario, just try to work it out amicably. I would, even if maybe somebody who needs a place to rent, and you could explain to them the situation. They say, hey, I don't care. I'm just looking for a place to rent. You could then go to the landlord and say, hey, I've got somebody willing to take over the rest of the lease. Can we work something out?
Yeah, I mean, in today's housing market, I'm sure they could probably put someone in there pretty quickly, but be careful too, because you may have a tough time finding another place, because I know prices of places are
all jumping up. Everything is going up. So the grass isn't always greener, and maybe having just a little higher of a electric bill every month is better than having a much higher rental bill every month.
So do that research before you make a decision.
Yeah, about like $20 on the electric bill is probably worth more than the $200 if you go somewhere else and the rent is higher.
Exactly.
Let's go on to another one here. I've got a question. I'm an entertainer once a week somewhere. They don't pay me after a while. When we agreed to paying me a certain rate weekly, how much do they need to? How much do they need to be in something before getting an attorney involved? So it sounds like this person has almost sounds like a verbal agreement about payment.
Yeah, it sounds
they keep
like
forgetting to pay this.
Yeah, they're not being paid
he's
timely,
not regularly paying. Yeah.
So if there's no contract that says, hey, you're supposed to be paid within 7 days, 10 days after a performance, it's subject to kind of reasonableness interpretation. So, I would kind of nicely remind them. Maybe you send them an invoice and say, hey, please pay within 7 days. Follow up with them that sort of thing. And this is why it's always best to have contracts. I know in these kind of performance situations that doesn't always happen.
Right.
But, after a reasonable period of time goes by, that's when, maybe you threaten legal action or take legal action. But again, the better course of action would be to first follow up with them in writing, say, hey, I performed in such and such a date. I would certainly appreciate if you could get me paid my whatever is owed by this date. Then that date passes, you follow up again, because now you're creating a paper trail. You're creating a paper trail that you can use in court if it ever leads to that. And so if they continue not to pay you, then you can take them to small claims court. But, without any sort of documentation, without any sort of paper trail, their defense could simply be, oh, I thought you were performing for free.
Yeah.
There's no contract. There's no agreement as to what you were supposed to be paid, when you were supposed to be paid, or anything like that. So that's why you always want something in writing. Contract's best. Some sort of written communication is not the best, but better than nothing. Something that you can show the court as to, hey, there was an agreement here. I was to be paid this much, and I was supposed to be paid within this period of time.
Well, yeah, I know some bands that when they play, regular shows at, regular venues, sort of things, they'll work out contracts with that venue that says, hey, and they'll do it like on a month by month basis. So it's like, hey, we're going to play these 2 Fridays, and you work out a contract. And it's as simple as that. And you could do it month by month. They could set it out for 5 months, 6 months, however long, really. But even something as simple as that could help.
Yeah, the more professional bands who do this all the time typically have that kind of, that documentation already worked out, because they've either had issues in the past that they've learned from, or they know people who have, and they've learned from that. So they've gotten wise to it pretty quickly.
Let's go on to our next one here. And if you want to send an email, if you've got a question about something related to that or just a general curiosity, again, ask at DeWittLaw.com. Straightforward, simple one. We've actually talked about this before on the show, but it's always a good one to rehash here, Mo. What is the difference between stacked and unstacked motorist coverage?
So stacked is basically if you have multiple cars on a policy. Well, first of all, let me back up. Let me talk about uninsured motorist coverage, because, it's one of my favorite topics.
Yes.
So as, I've said many times, I think I said about 13 times on the show last week. I'm making up that number.
It's close.
Thank you. So in Florida, as you know, there's no requirement that you have bodily injury coverage. So someone can legally be on the roads, they can hit you and hurt you, not have to have any insurance coverage to cover you, and they're legally on the road. That's why uninsured or underinsured motorist coverage is so important in Florida, because it steps into the shoes of the at-fault driver who hit you if they didn't have any insurance or didn't have sufficient insurance. So when you buy uninsured motorist coverage, there's 2 types that you can get. You can get stacked or you can get unstacked. And so what stacked does is it basically takes whatever the amount of coverage is. Let's say you have $10,000 in coverage on uninsured motorist coverage. And let's say you have 3 vehicles on your policy. Well, it's going to take that $10,000 in coverage and stack it on top of the 3 vehicles. So if any one vehicle is in the accident, they can use up to the full $30,000 in uninsured motorist coverage. That's stacked. Non-stacked coverage is you're just limited to the $10,000 per vehicle. Even though you have 3 vehicles on the policy, your total uninsured motorist coverage is going to be the $10,000 that you purchased. And now the reason it's that way is because your bodily injury coverage cannot be, your uninsured motorist coverage cannot be greater than your bodily injury coverage. So if you have $10,000 in bodily injury coverage, the maximum uninsured motorist coverage you can have is $10,000.
And so I imagine that it would probably cost a little more to do stacked.
It does.
But if you have multiple cars, it probably makes just as much sense to do the stacked in that.
It does. Now, the other trick is, sometimes people have multiple cars and then they get rid of one car and they're still paying for stacked uninsured motorist coverage, but they only have one vehicle.
One car.
So you want to check your policy and say, if I'm paying for stacked and I only have one vehicle, that's just a waste of money because it is a little more expensive. So you want to make sure you go down to the non-stacked in that scenario.
There you go. That's some good advice there. A good one from Mo. And that, again, just a good little email. Probably someone saw that on their insurance and was like, I don't know what this means. Can you explain it? One more here. My HOA raised their fees by $10 a month. How can they do this?
So, in Florida, at least, the HOAs are always governed by their governing documents. So typically, whenever you move into an HOA, there's a declaration for the HOA. Basically says, it's basically a contract with all of the landowners there. It's a contract that runs with the land. So if you purchase a property in that HOA, you're subject to the contract that runs with the land. You're subject to the HOA documents. And so typically those documents are going to state how each member of the HOA is charged based on square footage or lot size or whatever it may be.
Right.
Now, there's typically also a provision in there on how those terms can be modified. And it's usually by some sort of a vote, and they need a certain percentage of the HOA to ratify that vote. And there's a procedure for how the voting has to take place, and there's a procedure for what percentage they need to get it passed and all that kind of stuff. So in short, that's how the fees change, is somebody votes on it. But you want to make sure that if that happened, they followed the proper procedure, they gave proper notice of the vote, whatever was going to be happening, and that it followed everything that's outlined in the declaration for the HOA.
So there is a good chance that this person had been notified that this was going to happen and just maybe missed it or something like that. But either way, if maybe there's an instance where an HOA did just randomly decide, hey, we're going to up this price and not do the vote and everything like that, which you can't do, there's at least a paper trail of sorts that this guy can track and make sure that they did do everything properly and that it is a legitimate $10 a month extra.
Right. You should be very, very easily be able to track whether there was a proper election or whether somebody just decided to increase the rate for no reason. But typically, and it could be a special assessment. There's all sorts of things it could be, but they should have a pretty easy explanation for it. They should be able to show you, when the election took place, who, how many votes were cast and that it actually did pass.
Are there ever, is there any, and this is just kind of going off topic a bit, but with the HOA, like, 'cause I don't have an HOA. Do you have an HOA?
No, I don't.
So I just, is there any bounds that they have, or can they pretty much just run the neighborhood to every degree?
So, that's a fight we see all the time. And one of the most contentious lawsuits are with HOAs that I've seen.
Yeah.
And so there are constraints that they have, the biggest one being the declaration, the terms of the declaration. And there are also some statutory boundaries that they have in the state of Florida as far as what they can and cannot do. But, with these, what we call kind of covenant lawsuits, for instance, where they say, okay, you have to maintain your yard in a neat and, proper manner.
Mhm.
And somebody has a yard that's, has a couple brown spots on it. And, there's a whole
Right.
lawsuit where the HOA is spending $100,000 litigating this issue. I mean, frankly, I would think people have better things to do with their time and money, but the problem is you get somebody who's in charge of the HOA who does this kind of thing. I mean, we had a case where it was a grandmother who put up a portable basketball hoop that she would like wheel out in the driveway, set up for the grandkids when they came over, and then she'd take it down and wheel it back into the garage. Well, the HOA sued her over that and said it was a violation of their covenants. And we looked at the covenants and said, no, it's not. What you say is prohibited is mounting a basketball hoop above the garage on the home. And so it went all the way to trial, and the HOA lost, and they actually had to pay our attorney's fees on that.
They didn't want to roll out a rollout basketball hoop.
And
like when
the grandmother, after she got the letter, she got rid of the basketball hoop a lot. She just didn't want to deal with it. She goes, this is a headache. I don't want to deal with it. The grandkids can go play basketball at the park down the street. I don't need to deal with this. But they still went forward on the lawsuit. They said that she violated the terms of the HOA. And, at a certain point, what happens is, the HOA started pursuing this. Well, now they owe their attorney's fees.
Right.
So they want to take it all the way to try to collect the attorney's fees from the homeowner. And in this case, they would have been better off just to drop the lawsuit because they ultimately lost. But a lot of times I think that's what it turns into. And it's just a small issue that then just becomes a huge battle over money, essentially.
And I'm sure not all HOAs are bad. I'm sure there are plenty of fine, normal, regular HOAs that don't nitpick and are just like, whatever, life is life. But you're always going to hear the stories about the nightmare situations. Yeah. There was the person in Tampa who had the Christmas lights professionally done up.
Yeah.
And they had to do them early because it was the only date that the people had available. And after they had it done, the HOA said, you have to take them down. We don't allow Christmas lights till this day. And they were like, well, I had them professionally done. Can I just at least have them up and not turn them on until that day? And they said, no, they got to take them down. And it's like, what are we doing here? Like,
yeah, I mean, again, a little reasonableness and everybody, be fair and friendly and nice to each other would go a long way. But unfortunately, that's not always the way things work.
And that's why I'm glad I do not have an HOA. If you want to send it an email, you can. ask@DeWittLaw.com. We'll have more of those next week. ask@DeWittLaw.com. And if you want to call and set up an appointment with Moe and the law firm, you can at 1-800-DeWitt-Law, 1-800-339-4885. The Moe Pro Tip of the Week coming up. DeWitt Law Review, WDBO 107.3 FM and AM 580.
Story time. So I want to tell you a little story about a call I got about a year ago. This guy gave me a call. He was just in a car accident. And I talked to him for a while. I told him what to do. Told him he needed to go seek medical treatment and get checked out. He said, thank you. I appreciate your time, but I'm not going to hire you. So not a problem. If you have any questions, concerns, let me know. Happy to talk to you anytime. About 2 weeks later, I was actually in the Bahamas. About 2 weeks later, he called me back and he goes, spoke to the insurance company. They're offering me $770 and they're saying I'm 30% at fault for the accident. You're hired. Sent him the paperwork, got him signed up. That was about a year ago. Today, we just settled his case for $100,000. The insurance company wanted to pay him $770 to resolve that claim. And this is just a prime example as why you should never settle with the insurance company that soon after an accident. You don't know what your injuries are. You haven't gotten checked out by a doctor. You don't know if you're going to need surgery or if there's a tear in a ligament or something more substantial. So when the insurance company offers you quick money after an accident, typically they're offering you pennies on the dollar to go away. And the last thing they want you to do is to hire an attorney because they don't want to pay you the fair compensation that you deserve.
Last segment of the DeWitt Law Review here on WDBO 107.3 FM and AM 580, Orlando's News and Talk. Don't forget to check out Moe on social media at the DeWitt Law Firm, Twitter, Facebook, TikTok, Instagram, whatever you got, they got. Go ahead and look him up. He does a lot of fun stuff there. And also don't forget Facebook and YouTube at DeWitt Law Firm. And you can watch past shows. You can watch this show if you missed the whole thing. You can go back and catch up on it. It's where we'll be posting the future shows as well. So go ahead and check all that out. Like, subscribe, whatever you got to do with all those different social media platforms. In the meantime, though, Mo, let's go ahead and give them your pro tip of the week.
Sure. So, nothing really mind-blowing this week, but we've talked about, earlier in the show, someone was asking a question about getting paid. And, in that case, they were just doing things verbally. They didn't actually have a written contract. And so anytime, as lawyers, we're kind of trained to think worst case scenario. We think what happens if things don't go well, things don't go as planned. And so you always want to, operate in a sense that you're protecting yourself. And whether that means having a contract with someone you're doing business with or having some sort of communication in writing, documenting the agreement, you want to make sure you're protecting yourself at every step of the transaction. And so, whether it's dealing with a contractor, when you're doing renovations on your home, making sure that's in writing and properly documented, or whether it's doing a business deal or a transaction with a friend or a family member. We see a lot of times where those go awry. The more written documentation that you can have, the better you're going to be, and the better you're going to be at protecting yourself if things go wrong, if you end up in court. Because ultimately, what happens in court is what you can prove. People say, well, this wasn't fair. It's not what's fair, it's what you can prove.
Right.
So if you're going in and say someone owed me this amount and they didn't pay me, you have to show that they agreed to pay you that amount and that you rendered the services and that they had agreed to pay you X, Y, Z for those services. So whenever you're dealing any sort of transaction like that, it's always a good idea to, whether it's a follow-up email or text message, best case scenario would be a contract, to have something in writing that you can document the transaction with if things go awry and you do ultimately end up in court.
Even if you think it's kind of the smallest, most mundane thing that you then think, well, what could go wrong? Well, that's what could go wrong, right? Is when you think what could go wrong. And I any sort of transactional thing where, even if you're getting work done on your car, you're getting, something done with your house or whatever like that, whoever you bring in to get that, make sure you have a complete list, a detailed description of the work they're going to do, how much each little bit is going to cost, and itemized it all out. Because what you don't want is them to just kind of say, oh, well, we'll probably ballpark it around here. We're thinking this. And they go and do a bunch of work and say, hey, you're going to owe us this now because we had to do all this extra stuff. And it's like, well, wait, I didn't agree to do any of that extra stuff. And it's like, well, no, but you said you wanted us to get this done in your house, and that's what it ended up costing us to do. So you got to make sure that in all those situations, you go ahead, get things itemized out, detailed out, writing, whether it be like we talked about with you're doing a gig at a bar or restaurant once a week, or you're getting work done in the house. Like, it's very, very important. Mo, another fantastic show, another great pro tip of the week. We appreciate everyone tuning in and joining us here this week. If you want to get in touch with Moe and the DeWitt Law Firm, don't forget you got to give them a call at 1-800-DeWitt Law. That is 1-800-339-4885. Also at DeWittLaw.com. Remember, DeWitt with 2 T's. Send us those emails, ask@DeWittLaw.com. And also, don't forget to check out at DeWitt Law Firm on Twitter, Facebook, YouTube, Instagram, all of that good stuff. You can check out this show, all of it in its entirety, and this will put all the upcoming shows as well. I think we got one train in there today, Mo. We got a few more train shows, so we'll have some fun with that, and we'll talk to everyone next week. Same time, same place. For Moe DeWitt, I'm Chris Crawford. You've been listening to the DeWitt Law Review on WDBO 107.3 FM and AM 580.
There you go, Crystal. $200 gift card. Congratulations.
Can I give you a hug?
Of course, yeah.
I hear you on the News Junkie all the time.
Thank you. I'm glad you came out.
Me too.